All right. What is up, everybody? This is Cam from Epic Conversions. Hope you guys are doing amazing out there on this fine Thursday afternoon. I wanted to talk to you guys about copyright when it concerns AI. I know I'm kind of developing this reputation of being someone who hates AI. Um, I guess that's not untrue. I can't say that's not true. I guess I'm not a big fan of AI. But look, I've used AI before. I've been testing its limits for a few years now. I feel like most of the people I serve in my market and the online business market and the make money online space, most of those people are fans of AI. Most of my customers are fans of AI. They like AI, so I have to know about AI and I have to understand what it's all about. So one of the problems with AI since the very beginning has been copyright. Who owns what you create with AI? And the fact of the matter is, as it stands, nobody does. You cannot claim a copyright. You cannot register a copyright on anything you create with AI, right? And the laws surrounding copyright when it comes to AI are slow to catch up to the technology. However, they are starting to come in, right? Laws are starting to take form, and they're starting to figure out how they want to handle AI. But for a while, and since the beginning, when you create something with AI, it's essentially in the public domain. It is essentially non-copyrightable content, which makes it the same as like a recipe. There are certain things like recipes, statistics, simple ideas. These things are not copyrightable, right? So generated AI content falls into that category. It's not something you can copyright, which means that like if you write a book with AI, that book might as well be in the public domain. Anybody can take that book and sell it themselves. Imagine you use AI to create a book, and then someone takes your book. Listen, it doesn't matter if there's forms of expression involved in it or not. If you used AI to create it, and you used AI to create the cover for it, and it's all AI done, anybody can take that book and they can sell it as their own, like it was public domain. So that's something to keep in mind. The plot thickens, right? So there was a Supreme Court ruling just about a week ago. March 2nd, 2026, the U.S. Supreme Court, I got this right here, I'm reading from it, declined to hear Thaler versus Perlmutter, okay? Letting stand lower court rulings that AI-generated works without human authorship cannot be copyrighted. This decision upholds the U.S. Copyright Office's requirement that only works created by humans are eligible for protection, cementing that AI is a tool, not an author, under current law. Cementing that AI is a tool, not an author, under current law. Key details on the decision. Case background. Computer scientist Stephen Thaler sued the Copyright Office after being denied a copyright for an image created by his creative machine, AI. He basically had a creative machine, a GPT, if you will, arguing it should be protected. So he used his AI, he prompted it to create this image, and he felt like he should be able to claim a copyright on this image. He should be able to register a copyright on this image, right? The Copyright Office, U.S. Copyright Office, denied his registration. They said, it wasn't created by humans, so you can't register a copyright on it. He sued them, okay? He sued them, and he said it should be able to be copyrighted, all right? And what has happened recently, just about a week ago, was the Supreme Court threw it out, saying the Copyright Office's decision stands, okay? So legal standing. By denying to hear the case, which is what happened about a week ago, the Supreme Court upheld the D.C. Circuit Court's 2025 opinion that the 1976 Copyright Act requires human authorship. Industry impact. This decision reinforces that for AI-generated works to be copyrighted, they must involve significant human creative input. So here's where I think that people get this twisted a little bit. You think that because you put in a significant prompt, the prompt is like 3 paragraphs long. It's a giant prompt. It's very detailed. You worked really hard on this prompt. And because of that basically equals, human authorship. That equals significant human contribution. So the Copyright Bureau, the Copyright Office argues that if you take that exact same prompt and you feed it into AI again, or you'll get a different picture, So like if you got a prompt that you worked really hard on and you feed it into AI and it gives you an image, and then you feed the exact same image and you feed the exact same prompt into AI again and it gives you a different image, the Copyright Bureau is arguing that you have no contribution to the creation of that image. If you would have had a contribution to the creation of the image, it would give you the same image again because you entered the same prompt. So it would give you the same image, but it doesn't. So that's the argument that's happening right now. So anyways, let me read on. So future implications, all right? While this case focused on fully autonomous AI creation, it leaves open questions about the exact threshold of human input required for copyright protection, right? Because guys, keep in mind, right now, AI created work has no copyright protection, right? If you see AI created images out there, it is open season. You can take any of that stuff you want and use it in any way, shape, or form that you like. It is open season right now. And the funny thing about it is, here's the funny thing about it. If we follow traditional copyright law, okay, what's going to happen is when they do make a decision on copyright law, what's going to happen is anything that was created before that copyright law took effect is still going to be like non-copyrightable. It's still going to be like in the public domain, right? Because, the law is not going to affect stuff that was before, right? Stuff that went public domain, stuff that was non-copyrightable before, it's not going to change that, I believe. Now, I'm not a lawyer, okay? This is just my understanding of copyright law. I could be wrong about that, but I don't think so. I think it's only going to affect things going forward from the law. It's not going to affect things that were already created. So I would keep that in mind. So while this case focuses on fully autonomous, it leaves open questions about the exact threshold of input required for copyright protection, okay? Now this is funny, all right? This is really funny because so many people out there are using AI for their articles. They're using AI to write entire book series on Amazon. They're using AI to create movies and short films. They're using AI to create, art, comic books, all kinds of stuff. They're using AI to create all this stuff, and none of it's copyrighted. It's like the inconvenient truth that I don't hear anybody talking about. Everybody's ignoring it. But man, I'm telling you, this stuff is open season. It's just a matter of time before the public domainers, the people who, take advantage of the public domain and they take advantage of non-copyrighted content. It's just a matter of time before they catch on and they start just going open season on all these people using AI to create all this stuff. Just a matter of time, man. Anyways, the ruling is a significant yet not final step in establishing legal framework for artificial intelligence in the United States. So to qualify for copyright, the U.S. Copyright Office requires that a human maintain creative control over the work's expressive elements. There is no percentage of human input required. Instead, the Copyright Office evaluates whether the AI was merely an assisting instrument, or if it actually conceived and executed the traditional elements of authorship. like specific artistic or musical expression. See, this is the problem. The problem is people want to say my prompt is what created that artwork, or my prompt is what created that musical composition. I'm the one who came up with the detailed prompt that created that. That's what people want to say. That's the argument. But the Copyright Office is saying no, because if you entered in that same prompt again, you'd get something different. It wouldn't be the same thing. So no, you did not in fact have anything to do with the creation of that composition or that piece of art. The AI created that art. You did not create it. And we only register copyrights for humans, not for AI. AI is just a tool. Do you guys understand? There's a deeper argument at play here. And this is why you have to understand, this goes beyond copyright, okay? This is not really about copyright. So it looks like it's about copyright, right? And you got all these people who use AI who want to get copyright for their AI work, right? But like it's probably not going to happen. It's probably not going to happen. Because look, that's probably a story for another video. But this has a lot to do with, is this a tool or is this a thing? Is this a thing, right? Is this a tool or is this a thing? Because if it's a thing, then we have to grant it a copyright, right? But if it's a tool, then we don't have to grant it a copyright. We don't grant copyrights to things made by AI, right? Because if you granted copyright to things made by AI, then you would have to think about AI rights now. Now you would have to admit that this is not a tool. Maybe this is more than just a tool, right? So it leaves copyright in a gray area because the Copyright Bureau refuses to acknowledge that your prompt was a significant portion of this, creation, and yet, so it's a catch-22, right? The Copyright Bureau is saying, well, hey, look, if you enter the same prompt in again, you get something different. So you didn't have anything to do with the creation of this piece of art, or you didn't have anything to do with the creation of this composition, right? So they're saying that, but then at the same time, they only grant copyrights to humans, right? So they're not going to grant a copyright to the AI because it's not human, and yet they're not going to acknowledge that the human created this work because they don't feel like they did create this work. So it's a really, really weird, slippery slope, and you got to wonder how it's going to turn out. I don't know. I don't know how it's going to turn out. So there is no percentage, of human input required. Instead, the office evaluates whether the AI was merely an assisting instrument or if it actually conceived and executed the traditional elements of authorship, like specific artistic or musical expression. So current Copyright Office guidance, prompts are generally not enough. Okay? Simply providing a text prompt, no matter how complex or how iterative that text prompt is, and that means, like, let's say you keep track of the list of prompts. Like, let's say you have the initial prompt, and then you have a second prompt and a third prompt, and it takes you like 78 prompts to finally get to the image that you want, or it takes you like 100 prompts to finally get to the musical composition that you want. That's iterative, right? They don't care how iterative it is typically seen as providing an unprotectable idea. It's an unprotectable idea rather than a creative expression. So what they're saying is, if I walk in a room and I say, hey, you know what would be really cool? You know what would be really cool is if they took like thing A and like they combined it with thing B and like they created a whole new thing. How cool would that be? Wouldn't that be neat? I said that. It's like an idea I had, and like someone overheard that idea and said, "Oh, I'm going to do that." Right? And they do it. Right? And like it was just an idea. You can't copyright an idea, right? that other person took my idea and ran with it and they did it, right? That's why, like, you had the NutriBullet that came out, okay? You had the NutriBullet that came out, and then guess what? I think it was like maybe a year later, you had the NutriNinja came out, right? So you had this bullet blender, the NutriBullet, and then a little bit later, Ninja came out with the NutriNinja, because you can't copyright an idea, and they were allowed to do that. You cannot copyright an idea. So again, the Copyright Office is considering these prompts. They're looking at them like ideas. The prompts are just ideas, and you're not actually the one who is creating the thing, right? That's how they're looking at the prompts. So if all you're doing to contribute is a prompt, they don't consider it, contribution to the actual thing, and they're not going to grant you a registration on the copyright. It's really, really funny because, I mean, they don't want to consider the AI a thing. They don't want to consider a living creature, right? Because if they considered it a living creature, then that would be a whole another can of worms, because now we're talking about what? We're talking about slavery? What are we talking about? What are we running, like a zoo now? If this is a living creature, are we allowed to hold living creatures hostage and make? I mean, can you imagine, like, you got monkeys at the zoo? Can you imagine if you took all the monkeys at the zoo and you trained them on how to pedal stationary bicycles, and that's how we powered the electricity grid with stationary monkeys pedaling electric bicycles. That's how we powered the whole thing, right? We trained these monkeys. It'd almost be like slavery, right? So like, if we can't have slavery, so if we acknowledge that AI are like some kind of weird sentient beings, that might be like slavery, right? So there's a very, very little chance that that's ever going to happen. So what does it mean? Does it mean that eventually they're going to, say that you can copyright things that are made with AI? I don't know. Copyright Office definitely doesn't think so. So anyways, so prompts are generally not enough. Simply providing a text prompt, no matter how complex or iterative, is typically seen as providing an unprotectable idea rather than creative expression. The AI, not the human, is considered the author of the resulting expressive details. What does that mean? It means that it is not copyrightable because the author is a machine. And they don't award copyrights to machines, all right? So it's not copyrightable. It's essentially in the public domain. That's what I'm telling you. Anything created with AI is in the public domain. And I've been saying this for 3 years, right? And 3 years later, I'm still saying it. So permissible human contributions. A work containing AI-generated material can be copyrighted if a human provides creative arrangement, selecting and arranging AI-generated elements in a sufficiently creative way, e.g. a comic book with AI images but human-authored text and layout. So if you have a comic book and the human wrote the story and the human laid out the AI images, right? The human had laid out images, then you could get awarded a copyright on that. You could have a copyright registered on that. The thing about it is, what I have read on that is that, like, you still can't get a registered copyright on the actual artwork in the comic book, but just on the comic book as a whole piece of work, you can get a copyright on. But it doesn't mean that people can't take pieces of that comic book that AI created and, like, use it, right? It doesn't mean that, because they can do it. If AI created like a tree, and a mountain behind the tree in the background, it created the scene in your book. People could take that scene and use it in their own comic book, okay? They just can't, like, use it like the same way that you used it as a whole, including the layout and the text and the writing and the comic book as a whole. They can't use the whole thing, right? Because that's creative expression. But just that individual AI created artwork in there, that's basically public domain. So essentially, the Copyright Bureau is treating AI artwork and AI writing and AI music, they're treating it like public domain content, okay? You can use it to create derivative works if you want to, but it's not a moat. You have no moat for this stuff. You cannot protect it. All right. Subsequent modifications, taking an AI output and significantly editing or transforming it into a new human authored work. So if you take an AI image, like something the AI created, and you significantly edit it or transform it into a new human authored work, you can register that. You can register that. So these are some of the kind of like things that would be permissible according to the Copyright Bureau, okay? And they are the gatekeepers for registering copyright. Now you might think, well, hey, don't I have a copyright as soon as I create something? Yes, you do. However, usually the only way to prove it in a court of law is with a registration for the copyright, right? That's usually the only way to prove it. Usually they won't acknowledge any other proof besides, a registered copyright. So there's that. And according to the Copyright Bureau, if you used AI to create something, no copyright was created no copyright was formed automatically when that was created, because it wasn't created by a human. All right, original input. Using a human authored work as an input prompt, like an original sketch, where that work remains perceptible in the final AI output. So, if you create something using AI, like we're talking about art here, right? And the way you start this creation is you upload an image to AI, right? Like a photograph that you took, or like an image that you drew. And then you have AI do things to it, right? But that original work is still perceptible in the final equation, and in the final output, you can still see where it came from. Then the Copyright Bureau, right, the Copyright Office will probably let you register a copyright on it, right? They consider this significant human input, right? Mandatory disclosure. Applicants must explicitly disclose the use of AI in the registration. Failure to do so, such as claiming an AI-created painting as entirely your own, can result in the cancellation of the copyright, and this has happened already. Case-by-case review. Because AI tools vary significantly, the office examines each application individually to determine if the human's role rose to the level of authorship, right? They are turning down people left and right for registration of copyrights since all this AI stuff started. Legal boundary is currently being tested in cases like Allen versus Perlmutter, where an artist is challenging a denial of copyright for an image created using over 600 iterative prompts and manual edits. Okay? So this guy had 600 iterative prompts on this piece of artwork and manual edits, and the Copyright Office turned down his registration. Okay, now listen, Thaler versus Perlmutter, this is the one that just got turned down last week. This was fully AI generated. This is the case recently reached the Supreme Court, which officially declined to hear the appeal on March 2nd. They declined to hear it. They said take this down to state level. The DC Circuit, they held that purely AI generated work cannot be copyrighted. Remains the final law for that case. So now we have precedent. Now we have precedent for anything that was 100% created by AI, but we don't have precedent for like what is the level of human involvement to where you can get a registration, right? We don't have that precedent set yet. So the new one is Allen versus Perlmutter, okay? Now this case involves artist Jason Allen and his award-winning image Theatre d'Opera Spatial, right? And I'm probably saying that wrong. This is like a French word. But this is an award-winning image. By the way, although this is saying it's an award-winning image, it's important to know that that award was taken away. As soon as they figured out that he created this with AI, the award was taken away, as far as I understand, if I remember this correctly. Jason Allen won the award for his image, Theatre d'Opera Spatial, but I'm pretty sure it was taken away. Unlike Thaler, who claimed his AI was the sole author, Allen argues his 624 prompts and manual edits constitutes enough human authorship to qualify for copyright. Now, this case is viewed as the next big test because it focuses on AI assisted work rather than purely AI generated work, right? So, as of late February 2026, both sides in the Allen case have filed motions for summary judgment in the Colorado District Court, meaning a judgment there will likely issue a ruling soon before it can be appealed to higher courts. So this is the battle that's playing out in real time when it comes to AI, and this is everything AI, okay? This is all content created by AI. Don't get it twisted, think this is just about art. This is not just about art. This is about art, writing, music, video, everything, right? This is going to affect a lot of things. Think about these studios right now that are trying to replace actors with all AI generated stuff, you know? In fact, I was just reading the other day that these actors are talking about going on strike again. They're very unhappy with AI. They're going to start trying to use AI for like extras, like background when you're having these movies and people are, talking in these movies and stuff, and you got like extras in the background walking around. They want to start replacing those people with AI, I saw a video the other day. It was like Tom Cruise and Brad Pitt. They were like fighting on this bridge. They're in this like martial arts battle, and it was all AI. It was all AI. So this stuff's getting really, really good. But these kind of rulings in the district courts and in the Supreme Courts, they're going to start determining what it can be used for and what it can't be used for. Because the fact of the matter is, as it stands right now, anybody creating this stuff with just like AI, none of this stuff is copyrighted, right? It's just not copyrighted. People creating movies right now, people are creating full-length movies with AI, completely not copyrighted whatsoever. So anyways, it's something to keep an eye on. We'll see how it goes. Now, I know a lot of people in my space, the information marketing space and the online business opportunity space, I don't know if they care that much about it or not. I really don't. I mean, they're pumping out these books. They're pumping out special reports and information products and PLR like article packages as like fast as you can blink. And I guess they just don't care whether or not there's any kind of copyright involved in it. I think it's funny because they're trying to pump out these PLR packages and like they come with a license. You're offering a license on AI generated content? There is no license, bro. I can do whatever I want with this. If you're telling me on that sales page that you generated all this content with AI, I can do whatever I want with it, dude. I don't have to. I can disregard your license. It's AI generated content. So you really have no protection. You have no copyright. So you have no ability to create any kind of license for this kind of content. So it's very interesting. We'll see how it all plays out. Anyways, I'm Cam from Epic Conversions. Make sure you subscribe if you enjoyed this content. It's something to think about. I think that, what it boils down to is if you like AI and you find it to be a really cool, valuable tool for you, you need to pay attention to this stuff. You need to pay attention to these hearings and what's happening because right now, as it stands, you really have no protection on the content you create. If you're creating stuff with AI, anybody can just take your stuff and just do whatever they want with it. They have no reason. You have no protection. They have no incentive to not take it, other than they don't like it. But if they like it, they can just treat it like public domain and take it. So it's something to keep in mind as you move forward. I definitely think it's something that would give me pause if I was using AI to create a bunch of stuff. But to each their own. Anyways, I'm Cam from Epic Conversions. Subscribe to my Substack if you enjoyed this. I try to do these about 4 or 5 days a week. If you want to learn more about what I do with my business, make sure you subscribe to my email list. I'm at epicconversions.com. That's the best way to learn about what I do with my business and how I sell things and what I sell. My whole thing is I help small kitchen table entrepreneurs make more money. So if you're a small kitchen table entrepreneur and you've been struggling to make money online, but you've been having trouble, I can probably help you. If you've made some money online but you'd like to make more money online, I can probably help you with that. And that's what I do. I help small kitchen table entrepreneurs make more money online. So if that sounds good to you, subscribe to my Substack. Get over to epicconversions.com, subscribe to my email list, and I will see you in the inbox. Peace now.